Brian Claypool, what do you think this prosecution is going to do with Jane Doe number 1? Do they have strong enough of a split to justify bringing her back into court, putting her through this trauma again, making her testify, or do they let this one go?
Well, Seema, great to be back with you. I had a chance to speak with Dan Owens briefly a few minutes ago. And although he is not able to 100% commit to retrying all of these charges that resulted in a hung jury, he gave every indication that there's likely to be a retrial because he made it clear in that press conference that if a vote is in favor of a conviction at 7-5 on Jane Doe 1, that's a strong factor that the district attorney in San Diego uses to decide whether to retry. So I think you're going to see a retrial on Jane Doe 1.
Brian Claypool, he's like our guest Court TV reporter for the day. We appreciate the insight into Mr. Owens and what his process is. Brian, I'm going to ask you to stick around. More with Chanley Painter and Brian Claypool after this break. Back to Brian Claypool, who's a criminal defense attorney and live with us from San Diego. Brian, we remember this jury instruction that said that basically if you find beyond a reasonable doubt charges with respect to Jane Doe number 2, the jurors could use that in deciding charges with respect to Jane Doe number 1. This jury instruction clearly didn't work because they were hung on the counts with respect to Jane Doe number 1. Now, as a defense attorney, you are trying to not have a retrial with Jane Doe number 1. Is there anything about that instruction, or is there anything about the argument that the prosecutor was trying to connect Jane Doe 2 and 1 that would help you in arguing, let's say, double jeopardy has already attached? Well,
I don't think you can argue double jeopardy, but I think what I would do if I'm defending Kellen Winslow II in a retrial is I would think very long and hard about having him testify, because sexual assault cases, defending somebody charged with sexual assault is much different than, for example, a murder case. Why? Because in a murder case, the victim's dead. The victim does the murder victim can't get on the stand and say, hey, he or she did it. In these sexual assault cases, we heard you even got a 7-5 on Jane Doe 1. They all got up there and they thrashed Kellen Winslow II. And Brian Watkins made a comment in a press conference. He said, hey, there was no corroborating evidence. Well, that's right, but you do have other evidence from all Jane Doe 1 through 5. So I think they really have to think long and hard about getting Kellen Winslow II on the stand. He's going to have to refute these allegations, humanize himself, personalize himself, and that could be the minimizer and the game changer when this goes to a retrial.
Oh, absolutely. They have to do something different because we know that statistically retrials favor the prosecution, and especially with all of these splits. Now, with Jane Doe number 2, Winslow was found guilty on count 4, which is the forcible rape, but the jury was hung on the sodomy by use of force. The split was 10-2 in favor of guilt. How do we see this one playing out? If this goes to a retrial, I just can't see conceivably how the jury is going to hear about this. She's going to testify as to one count, and then the jury is going to know about the conviction of the forcible rape. It seems very convoluted.
Well, that's a great point. But before you even get to that, my appellate brain is thinking about another issue, because when I did 2 retrials for Dalia DiPolito in West Palm Beach, Florida, we had an appellate lawyer sitting in the first row of the courtroom, but in the entire both trials. And what I would be thinking about right now, if I'm the defense lawyers, I know it's a long shot, but I'd file a motion before Friday arguing that there's a potential inconsistent verdict as to Jane Doe number 2. And that's a grounds for getting a conviction thrown out. And what I mean by that is, how can you have 12 jurors rule on one hand there was a forcible rape of Jane Doe number 2, but yet not have those same 12 jurors find that there was sodomy. That could arguably be an inconsistent verdict and grounds to throw out that conviction. I would raise the issue.
Okay, I love the idea. I love that we're like legal nerding out right now with the motion for the inconsistent verdict. I think that's a great idea. But don't you think the hang up is, okay, so for the forcible rape, it was the vaginal intercourse, and the sodomy by use of force was the anal intercourse, the allegations of both. And Jane Doe number 2 even said she didn't know if the sodomy was by accident. And although you don't need intent, it's just the act itself was enough. But that could be the argument against the inconsistency.
Well, look, at the end of the day, I mean, if she's saying, I mean, you could even use that in the motion. Like if Jane Doe said, well, it could have been an accident as to the anal portion of this. I mean, if I'm Carlos and Watkins, I'm going to argue that the evidence doesn't support the jury verdict as to Jane Doe number 2. That she's saying, oh well, gee, it was an accident as to this, and remember, you had the forensic nurse too, right? She came in and said, hey, I can't tell. There's no forensic evidence here that supports a sexual assault. She said that. So you have that combined with Jane Doe number 2 saying, hey, the anal portion might have been an accident. I mean, I'd file two. I'm just thinking outside the box. I'd file 2 motions if I'm the defense lawyers. An inconsistent verdict on Jane Doe number 2, and also that the evidence simply doesn't support a finding of guilt on Jane Doe number 2. And getting back to your question real quick, I think if I'm Dan Owens and I'm retrying all these cases, I eliminate the sodomy charge as to Jane Doe number 2. Why? Because you don't want to create any problems in the retrial that's going to end up in a mistrial in the second retrial. You just don't need that. You already have the conviction on the forcible rape.
Okay, Brian Claypool, can I ask you to stick around? We have more to dissect in this verdict in California versus Kellen Winslow II. Folks, stick around. Our breaking news coverage continues after this. And that was Jane Doe number 4. Let's bring in Brian Claypool, criminal defense attorney, who is still live at the San Diego courthouse. Brian, before we get into Jane Doe number 4 specifically and the counts pertaining to her, the jury still remains, the jury was deadlocked. A mistrial was declared, and part of that declaration involved 2 counts involving Jane Doe number 4. That was the case from 2003 when she was only 17 and Winslow was 19 years old. I just want to look back with you because I had you on yesterday, I think we ended the program and then this partial verdict was declared. So the note before the partial verdict was declared was that the jury has come to a decision on 4 out of the 12 counts. Instead of asking the jury, and you and I discussed this, instead of asking the jury to kind of go back and respond in some fashion to the 8 remaining counts, the judge took the partial verdict. Do you think that the judge taking the partial verdict was the correct decision?
Thank goodness you brought this up because I was agonizing over this. I think the judge should have handled this differently. When he got that note, he should have done what you said. He should have either sent a note back or called in the jury and said, you need to continue to deliberate on the other 8 counts. I have no idea how it is. Maybe you can help me, but I have no idea how it is that a verdict was actually read on the 4 counts where there was a conviction. The judge should have simply said, "Okay, great. You've got 4 that you've got a decision on. You don't have a decision on 8. Go back and keep working on those other 8, and don't reveal to the world about the other 4." Here's why I think that was that wasn't the best.
Brian, have you seen this before?
Yeah,
have you seen something like this before?
I have no.
Okay, all right.
I have never seen. I've never seen a partial verdict read and jurors polled before while they're still deliberating 8 other counts.
Okay, thank you. We actually have, before we go on with this conversation, we have some sound, and this, I believe, is it Mark Carlos that we have? I'm sorry, we have Brian Watkins talking about this partial verdict being taken.
I think that that partial verdict somewhat helped because they were then in the ability, they had the ability now to say, well, we are undecided on the remaining counts. Go ahead and declare it a mistrial so that we can relitigate this again.
Okay, now he's not exactly saying whether he's seen this, but Brian, I will tell you, our lead anchor, Vinnie Politan, he's never seen this, and some producers from the original Court TV, they've never seen anything like this, and now you, one of the country's most premier legal minds, has never seen this. So do you think that everything almost fell apart because the judge did, in fact, take the partial verdict?
You bet. By the way, thank you for the compliment. But there's no question about it that what the judge did is he basically then gave this jury a reason to go back there and not reach a verdict on the other 8 counts. Because think about it. To get polled, when you get polled as a juror, that's a very, very profound and powerful thing to happen to you. You've got to say, yes, that was my vote. So think about it, Seema. You do that, and then the judge says, okay, by the way, oh, your job's not over, when everybody's feeling like it's over because they just got polled on 4 convictions. Then you're going to symbolically send them back into the deliberation room and say, keep deliberating. They're going to go back there with the mentality, look, we already did our job. We already got a decision on 4 of these. We're done, basically.
Yeah,
so I think that suggestively sent a message like we're history. We're just going to come back the next morning for an hour or 2, and we're deadlocked, Judge. That was a colossal mistake.
It was almost a retroactive deliberation. It didn't make any sense. Okay, Brian Claypool, please stick with me just for a little while longer. I'm going to miss you when this is over. You've been so insightful, and your expertise invaluable, my friend. So we're going to take a quick break.
I already have separation anxiety, Seema.
We're going to take a quick break, Brian Claypool. More Court TV Live on the other side of this. Let's bring in Brian Claypool to try and figure out why the jury could not come to a unanimous decision with respect to Jane Doe number 4. Brian, the split for Jane Doe number 4, count 7, the forcible rape was 10-2 in favor of guilt. And with count 8, rape of an unconscious person, the split was 8-4 in favor of guilt. Okay, so I spoke to Mark Carlos and Brian Watkins a little earlier, and my big question was, and a lot of people share this question, was what happened to Matt Vaughn and Chris Resto? Matt Vaughn was on the defense's witness list. Matt Vaughn was allegedly also with Kellen Winslow during this allegation of sexual assault that Jane Doe number 4 complained of. So let's just take a listen to what Mark Carlos said about why Matt Vaughn and another potential witness to the incident, Chris Resto, did not testify for the defense.
They were not interviewed by law enforcement, so they knew who they were. They didn't go out and interview them. They have, as you can probably tell, they have a right against self-incrimination. If Jane Doe 4's testimony alone was enough to levy a charge against Kellen Winslow, clearly her testimony alone would be enough to levy a charge against them, so against at least Matt Vaughn. So whether or not he has an attorney right now, we don't know. There are factors that come into play as to whether or not he can be called. I mean, like I said, he has a right to talk to a lawyer. But, we have to put people on our witness list because we don't want to be precluded from calling them. If we don't put them on a witness list, then we can't call them.
Brian, what was the hang-up with Jane Doe number 4? Was it in part because we didn't hear from Matt Vaughn and Chris Resto? And clearly, if Matt Vaughn was alleged to have been involved in the incident but testified for the defense, he almost would have been endorsing Kellen Winslow's innocence.
Right. That's a fascinating part about the 10-2 vote on Jane Doe number 4 and the 8-4. Because when this trial first started, I thought exactly what you did. I said, where's Matt? Where's this guy Matt? He's going to come in and he'll seal the deal one way or the other, right? And if he's buddies with Kellen Winslow, then the second, then I would have expected him to come in and mirror Kellen Winslow II's version. So he didn't testify. But to Mark Carlos's defense, he might not have control over that witness. He's not representing Matt. Matt might have a lawyer. Matt might be difficult. Matt might walk into a courtroom and who knows what. If Matt came in and pled the fifth, what do you think a jury would do with that, right? They're going to think, oh my gosh, something bad happened, and then they're going to impute that to Kellen Winslow II. So I think that was that good decision to not bring him in if he's not controlled. But I think the real reason why the jury didn't come up with a conviction on 4, and remember, I have to admit, I thought Jane Doe number 4 was the best chance at getting a conviction. I was surprised that it was Jane Doe 2, but I think with Jane Doe number 4, remember that time when she talked about it happening in a car?
Right.
And then she even admitted, and I know it, and she even admitted too. Remember, I thought Carlos or Watkins did a good job of getting her to admit that she contributed. Remember that?
Yes.
Like they asked her, didn't you contribute to the situation getting to where it was? And I thought those were two real game changers for the defense to justify why at least two to 4 jurors would not find a conviction on that one.
So, okay, we're still Jane Doe number 4. Part of the decision on Jane Doe number 4, the defense actually made an argument that this is why the deliberation should not have continued. Okay, so yesterday they got the note. They've only decided on 4 out of 12 charges. Then it was the deadlock note. And Carlos said, let's stay with the deadlock. Let's end this trial. Today, the defense comes in with a motion to dismiss. And in essence, they're saying the guilty charge for Jane Doe number 2, that charge in the verdict form, they found guilt for that count, rape by force or fear, but they said not true for the specification that basically says, hey, there wasn't more than one victim. So the defense is saying, if there wasn't more than one victim, we cannot deliberate on Jane Doe number 1 and Jane Doe number 4. Let's listen to a bit of sound, Brian Watkins discussing this.
There's the difference between our case and the Carbajal case. So in the Carbajal case, they found the allegation to be true, so that is not an acquittal. Here, they found it not to be true, which is an acquittal for all purposes.
Only for one count. So you're essentially stating that because they found the multiple victim allegation not true on count 4, that the other forcible sex crimes need to be dismissed?
Correct, because they said that there were not other victims. No rape occurred of other victims. That's what the multiple victims allegation states. They found that beyond a reasonable doubt and were polled as to that issue. So that is a verdict that was taken by this court and stands. There is no touching it, no readdressing it.
Brian, I thought that was a very powerful argument. I've got the motion right here. It was well researched. And even though distinctions were made from the case that was supporting the defense argument, and there was another case that was brought up, listen, this judge has the power to make precedent. The judge can actually go with the existing law and then make new law. But they lost this motion to dismiss. What were your thoughts about this?
Well, I haven't seen the motion to dismiss, but rest assured, that was filed for a reason. And I think this is important for a lot of your viewers to realize. Behind the scenes of these big trials that you're covering on Court TV, there are so many documents that are filed with the court. We were filing stuff almost every day in Dalia DiPolito's retrials. Why are the lawyers doing that? They are they're preserving the record for appeal. This motion filed today, you're raising a great point, will be the cornerstone, I believe, of an appeal. You raised a good point a couple days ago. This allowing the evidence of I get lost in a 2, 3, and 4 to prove 1. I mean,
right.
To me, that seems patently unfair too. Look, I would take that up on appeal too. I don't care what the law says. Maybe an appellate court will interpret the law differently and give you a more fair shot. But at the end of the day, before Friday comes, you're going to have a lot of work to do, I think, because there's going to be other motions filed by Carlos and Watkins to try to get this conviction reversed on Jane Doe 2.
Right, right. Okay, so just taking again this argument for the motion to dismiss. Okay, so they're basically saying, even though guilt was found for Jane Doe number 2, because of this specification that says not true, that there's not more than one victim. Can't the defense make an argument that this was litigated, that Jane Doe number 1 and Jane Doe number 4 were litigated, and that double jeopardy was initiated? Okay, so double jeopardy. I'm the loss for words. Double jeopardy clicked in, and therefore this cannot go to retrial. I'm just.
It can't be retried again.
I'm being a little creative here.
Yeah, they definitely. Yeah, they would definitely. They're definitely going to make that argument. And just so your viewers know, the double jeopardy means you can't be tried for the same crime twice. And this is a creative argument by Mr. Watkins and Mr. Carlos. And again, that's going to be one of, I think, several arguments. I would raise another one I mentioned a little earlier in your show about, I know you think it's far-fetched, but this inconsistent verdict on Jane Doe number 2. How do you find, the forcible rape, but no sodomy? But look, at the end of the day, Seema, this was a heavyweight match with really good lawyers on both sides. I had the privilege of talking to all of them for a bit outside your studio here, and these are really, really good lawyers. And there's a lot of emotion running thick in this case. Dan Owens even said that he saw on the faces of many of the jurors disappointment. And I was curious. I was like, what are they disappointed about it? The case is over. They should be happy. They're moving on with their lives, right? And he said he got the sense they were disappointed because that they didn't get verdicts on the other 8 counts. What does that tell you? Wow, this jury really did, most of these jurors really did care about what they were doing and the job and the oath they took in this case.
I think they certainly did, and I think jurors do take it to heart when they're given a job to do, they're asked to deliberate, they're asked to come to unanimous decision, and for whatever reason that doesn't happen, there can be a sense of failure that they did not see the process of justice to its natural endpoint. With that, Brian Claypool, I want to thank you so much.
Yeah.
More Court TV Live
Thanks
after
for having
this.
Me, Seema.